All right, so today we're gonna get started with the C401 2017. The C401 is a standard form of agreement between the architect and the consultant. And you would say, well, what do you mean by consultant? Is it just one? Is it, multiple? What's going on? So it is not just between the architect and like one consultant. It could be used for multiple consultants, meaning multiple forms of the C401 will be signed between, like, say, architect and structural engineer, or architect and plumbing engineer, or architect and electrical engineer, or architect and mechanical engineer, and so forth and so on. I basically mentioned all of them: structural, mechanical, plumbing. But any consultant that we may need to work with for a particular project, it's involved in here. And just like the B101, it has a date to it, and it states who the parties to the contract are. It also says, who the architect is, who the consultant is, what the discipline is, right? It could be anything. It could be interior design. It could be anything, any consultant form. Then here it says who the representative for the consultant is, who the representative for the contract for the architect is, um, and the B101 is referenced here, and it's being referenced as the prime contractor, the prime agreement. Sorry, the prime agreement. Okay, so every time they talk about the prime, they're talking about the B101, right? So it says the architect has made an agreement here and after known as the prime agreement, dated, and that is done with the architect's client identified as the owner and for the project. The architect and the consultant agree as follows, and then it goes through the table of articles. Just like the other ones, we have different articles. One is general provisions, two is consultant's responsibilities, three, scope of consultant services, four, additional services, five, architect responsibilities, six, cost of the work, seven, copyrights and licenses, eight, claims and disputes, nine, termination and suspension, 10, miscellaneous provisions, 11, compensation, 12, special terms and conditions, and 13, scope of the agreement. Yes, it is the same amount of articles as in the B101, or a kind of almost one-to-one comparison between one and the other, but they're between the architect and the consultant. Okay, and Article 1, General Provisions, it says 1.1, a copy of the agreement, of the architect's agreement with the owner for the project, referred to as the prime agreement, capital P, capital A, from which compensation amounts may be deleted, is attached as Exhibit A and is made a part of this agreement. So the compensation amounts may be deleted because the consultant doesn't need to know what the architect's getting paid. That's none of his business, honestly, right? So just like you don't hang out showing up your pay statements and how much you make, that's not something that we have like in our face. You don't just share it with the whole world. Um, so section 1.2, the portion of the project for which the consultant shall provide services is hereinafter called this portion of the project, P, capital P again, except as set forth herein. The consultant shall not have any duties or responsibilities for any other portion of the project. This portion of the project consists of the following, and they talk about what their portion of the work will be. Maybe something like structural engineering for the project, right? Mechanical engineering for the project, or some sort of inclusive sort of or general description. Then we have section 1.3. I mean, Article 1.3 says, to the extent that the provisions of the prime agreement apply to this portion of the project, the architect shall assume toward the consultant all obligations and responsibilities that the owner assumes toward the architect, and the consultant shall assume toward the architect all obligations and responsibilities that the architect assumes toward the owner. Insofar as applicable to this agreement, the architect shall have the benefit of all rights, remedies, and redress, I've never heard of that word, against the consultant that the owner under the prime agreement has against the architect, and the consultant shall have the benefit of all rights, the remedies, and redress against the architect that the architect under the prime agreement has against the owner. Where a provision of the prime agreement is consistent with a provision of this agreement shall govern. I mean, if one is inconsistent with this agreement shall govern. This article 1.3 is just really saying that, hey, whatever you kind of have to do to the owner, the consultant have to do to you. Whatever the consultant have to do to you, I mean, whatever the owner have to do to you have to do to the consultant. So it's sort of almost mirroring the responsibilities, matching the reward and risks from one to the other. Section 1.4 says the consultant is an independent contractor for this portion of the project. The consultant is responsible for methods and means used in performing its services under this agreement and is not an employee, agent, or partner of the architect. No, they don't necessarily work for the architect. They work for themselves. So they don't necessarily get a W2. Actually, they do not get a W2. They get a 1099, right? Something like that. You guys are familiar with 1099s, W2s, things like that? So one is an independent contractor type of relationship, and the other one is a employee relationship. So, for instance, here we have a consultant that does surveying, and he is a 1099 consultant. He works from his own home, from his own office. He doesn't work at our office and from our own location. He works there, and there is a difference between one and the other, which becomes very, very important to know for this practice management exam. What is an exempt versus non-exempt? What is a 1099? What is a W2? What are the different types of statuses that somebody can have to work for you? You know, so I want you to look into those, but that's beyond the scope of this class right now, of this session. So then then the consultant, again, the architect shall not be responsible for the acts or omissions of the consultant. The consultant misses something, that's something wrong. The architect is not responsible for that, right? So whenever there's an issue with a beam or a column or something like that, it's not the architect's responsibility. That if it's not adequately engineered by the structural engineer, it's not the architect's responsibility. Section 1.5, except as otherwise authorized by the architect, all communications between consultants and the owner, contractor, and or other consultants for the project shall be forwarded through the architect. He's saying they cannot email each other without referencing the architect in the email. Just like when people email somebody else here out of the office, all correspondence gets gets sent through either me or Marcos. At the end of the day, all correspondence goes through me. So because it goes through the architect, right? So basically, I'm just trying to illustrate it. So can the owner and the plumbing engineer talk to each other? Yes, only through the architect. So no, but only through the architect, not directly. Can they call each other? They will be in violation of this agreement if they were calling directly each other. If they conference call with the architect involved, then yes, right? It's almost like when you have a lawyer representing you and you go to court, he talks for you, right? And the judge is talking to him to talk to you. So it's not necessarily you talking. Now, again, trying to reference this so that you understand the relationships, contractual relationships. The architect shall be the administrator of the professional services for the project. We administrate the whole professional services for the project, all of them, and shall facilitate the exchange of information among the owner, consultant, and other consultants as necessary for the coordination of this project, of this portion of the project. So all communications, again, go through the architect. 1.6, if applicable, the architect and consultant agree to share the costs and expenses incurred in marketing, promotion, display, and procurement of this project as follows. If they agree, they could split, the costs associated with the project for marketing. Section 1.7, if applicable, the architect and consultant agree to share professional credit for the project as follows. This is about that credit, right? Like, hey, who they what, and how much of that project is owned by who as a design, right? The other consultants to be retained by the architect are as follows. Now, any idea why? Let's say I'm hiring a structural engineer. Any idea why I would want to tell the structural engineer who my other consultants are and other disciplines are, and the addresses and information.
I'm guessing because there should, when you're designing a structure, you need to know what is happening with the mechanical a little bit, and with the other consultants a little bit of coordination. That's
That's accurate. That is correct.
yeah.
Yes. So, for coordination purposes, although all of the communications do still go through the architect, um, they should know who they're working with. I mean, and on a very tamed, layman's perspective, to what if they don't even like each other, right? You wouldn't want they would say, no, I oppose, I don't work with that such and such mechanical, and they have the right to say that. They have the right to say, no, I'm not gonna work on this project because of such and such. That's it. That could happen. Hmm. So section 1.9, the sub-consultants to be retained by the consultant are as follows. If there are any sub-consultants that this consultant is retaining, let's say civil engineering is a consultant, and sometimes they hire a surveyor who is another professional who does surveying. So if they're to be hiring the surveyor, they would put it right here. Mhm. And it's because you may also have an issue with who they hire too, and you have to be able to, these are the team members. You have to be able to agree or disagree to them. Section 1.10, the parties shall agree upon protocols governing the transmission and use of instruments of service or any other information or documentation in digital form. The parties will use the AIA document E203 2013, Building Information Modeling and Digital Data Exhibit, to establish the protocols for the development, use, transmission, and exchange of digital data. Section 1.10.1, any use of or reliance on all or a portion of a building information model without agreement to protocols governing the use of and reliance on the information contained in the model and without having those protocols set forth in AIA document E203 2013, Building Information Modeling and Digital Data Exhibit, and the requisite AIA document G202 2013, project building information modeling protocol form, shall be at the using or relying party's sole risk and without liability to the other party and its contractors or consultants, the authors of or contributors to the building information model, and each of their agents and employees. In a nutshell, it's saying if you don't obey by E203 and G202, you're proceeding at your own expense, and I'm not liable to whatever happens with that instrument of service. And that was our general sort of articles there. So then we go to article number 2, consultants' responsibilities. Keep an eye on this because during construction, issues may happen, and prior to construction. But I would want to shed light on construction because you may get questions on construction evaluation where a beam was sized that was bigger than what it was supposed to be and it was installed wrong or whichever way. You got to look at who is responsible for what during what particular period of time. And here we'll tell you what the consultants are responsible for within their disciplines. So section 2.1, the consultant shall perform its services consistent with the professional skill and care ordinarily provided by professionals practicing in the same or similar locality under the same or similar circumstances. That is the consultant's standard of care. You don't necessarily put a standard of care of your own on them. You tell them you're practicing within your own standard of care. Period. The consultant shall perform its services as expeditiously as is consistent with such professional skill and care and the orderly progress of the project. If the standard of care set forth in the prime agreement for the architect services differs from the standard of care set forth in this section for consultant services, the consultant shall perform its services consistent with the standard of care in the prime agreement. Well, it's already binding them that if their standard of care that we're putting in our prime contract B101 is higher or lower, they got to go by that B101, not by this one. Does it make sense? So section 2.2, the consultant shall identify a representative authorized to act on behalf of the consultant with respect to this portion of the project and key personnel who will perform the consultant's services. The consultant shall not replace its identified representative or key personnel without the architect's approval, which shall not unreasonably be withheld. Again, they can just be changing the whole team and staff members, and you may understand why. Like for instance, sometimes we go for requests for qualifications or requests for proposals, right? And let's say we get the request for proposals, and I'm gonna make a very obvious example. And the project is all about African Americans and women, and you put the team to all show up with African American faces and women faces, and then the moment that the project actually gets granted to you, you let go of all those people, and then all of a sudden everybody's white and not female. But your qualifications were actually very much embedded into the fact that you were that minority sort of team. You may not proceed with the project because you just basically changed the whole roster of the team. Now that was one example, and that was just based on race and color. But what about qualifications alone, right? We've known that such and such have such and such experience, such and such qualities, such and such they graduated, blah blah blah, certificates, credentials. If you change the staff members, you're all of a sudden changing the whole team. Now, what he's saying is to the consultant, he's saying, if you're gonna replace them, just let me know. And you don't do it without letting me know. And I have to approve unless there's a strong reason why I shouldn't approve. All right. Now that doesn't really happen with us here at Flow as architects, meaning like the owners wouldn't want to work with us because we've changed the staff members or anything like that. But this is contractually here for the consultants. Okay, the consultant shall recommend to the architect the appropriate investigations, surveys, tests, analysis, reports, and the services of other consultants that should be obtained for the proper execution of the consultant's services. The consultant shall review the information provided by the architect and shall promptly notify the architect if the consultant needs further information to perform its services. One example of this would be we're calling a structural engineer, right? We're going to be building a building, designing a building at such and such location. The structural engineer now is a consultant to us, but for him to be able to engineer his structure, he needs a soils report. That's actually being done by a geotechnical engineer. So he may say right here, I would like some boring tests to be done on the site by a geotechnical engineer that will give me reports of the soil conditions so that I know what type of foundation I would recommend and design this building with. Does it make sense? Another one may be a civil engineer who does not have a surveyor in-house or a surveyor consultant. They may say, all right, I will do your utility plans and storm water management designs and septic systems design. And I'm just throwing some things that civil engineers typically do. And then they'll say, but I do need a consultant surveyor involved, or that you hire a surveyor who will give me, it says it there, survey, and report and information about the existing conditions, right? And things like that. So that's one example. All right. And again, and then the architect shall promptly notify, and they should promptly notify the architect of those consultants that are needed. Because that way we also let the owner know about it. And that way we compile the proposals. Right now here at Flow, we're kind of on that stage right now where we have a lot of substantially sized project. For us, substantially sized project, over 26 units or so, over 30,000 square feet or so. That to us is a very good size. And we are now kind structural engineers, mechanical engineers, plumbing engineers, electrical engineers, civil engineers, surveying teams, and everybody. And they are making their appropriate recommendations. Some of them have actually said, nope, I'm too small for that project. I cannot handle it, but I would suggest this and this. And they've done something pretty cool too. And I think it's important to say they actually have outlined the things that they are concerned about with the projects, like site conditions, soil conditions, or things are just that hey, you may want to look at this. And I like the fact that they've done that. No additional calls or anything like that. They just even some of them denied to do the project, but they are giving us that information, right? Those recommendations. That tells me a lot of good things about them. It tells me I do want to use them for in the future because they're very thorough. They actually looked through the project. They weren't just too busy or they weren't just not interested. The project was too big for them, and they understand the key elements that we will need to be concerned about within the project. I like that. I really, really like it, and I will always keep it in mind for a new project in the future. Because they kind of did that Article 2.3 without being even hired. So 2.4. The consultant shall coordinate its services with those of the architect and other consultants in order to avoid unreasonable delay in the orderly and sequential progress of the architect's or other consultant services. The consultant is responsible for coordinating his services with somebody else's services, with the architects and other consultants. That's another reason why we got to know who those other consultants are, right? So that they can actually coordinate it. And again, the consultant shall coordinate all aspects of its design of the work for this portion of the project with the work designed by the architect and other consultants as necessary for the proper coordination of the project. An example might be some duct work that needs to go within the plant, the ceiling space, and some beams that also need to go through there. So we want to make sure that they work with each other. We're not gonna be just randomly cutting through the beams. They gotta be a communication between the structural engineer and the, let's say, mechanical engineer in this case through the architect. Well, they will be able to mediate how to resolve that, right? And it's not really like it shouldn't be one designs and the other one adapts. It should be ideally. I'm throwing my 2 cents about how design should be done. It should be done together, like maybe a kickoff meeting where they discuss potentials and things like that, and then regular meetings. Maybe even just once every 2 weeks or whatever. That they would just sit down and understand what they're doing. Because one thing I personally hate is double work. Would you design something that won't work because and why did you decide that it won't work? Well, one, because you designed it alone. We don't work in a vacuum. Okay, we work as a team, and nobody knows everything, and that's why our standard of care is limited, right? It's just reasonable and prudent within the circumstances. So work with other people and ask questions. Call. It's just a phone call, and these days, just a little Zoom call, and you just, hey, do you have a few minutes to go through Zoom? And people are like, yeah, I'm actually working on the project, so why not, right? Pretty straightforward. Lately, I've been doing that a lot. Hey, do you have time for a FaceTime? Do you have time for a quick Zoom call? We have a few questions. The team has a few questions. Because I don't have all the answers to everybody here, right? And neither does the owner, and neither do the consultants. But within all of us, there is the potential for a good answer. Now, then, section 2.5. The consultant shall provide copies of drawings, reports, specifications, and other necessary information to the architect and other consultants in the format the architect requires. Well, their drawings. They got to provide their drawings. It may be just digital. Sorry, let me get my coffee. Then section 2.6. The consultant shall not be responsible for the acts or omissions of the architect and other consultants, contractors, subcontractors, their agents or employees or other persons performing any of the work. The consultant shall provide prompt written notice to the architect if the consultant becomes aware of any errors, omissions, or inconsistencies in the services or information provided by the architect or other consultants. What it's saying is, like the consultant is, let's say, reviewing the structural engineering plans. to understand how the structural engineering plans work with the plumbing. He realizes that the structural engineer is not putting a column, and there is a beam that's floating on space being held by one column only and not two. He sees that. He clearly sees that. He knows that, right? His duty right here is one, you're not responsible for the fact that that's there. That's not your fault. You got no fault on your own. But you are to let everybody involved in the project know about the error or omission that you've seen. And it's not even like, like, what is the word? No, I'm having a hard time with words lately. You're not just trying to shed, light into somebody else's problems to hurt them. You're not trying to, dig out dirt on somebody else. You're just really trying to protect the project and the portion of the project in which you're involved, right? And then we all just want a successful project, ideally, right? So that's what it is, all right? So section 2.7. The consultant shall submit for the architect's approval a schedule for the performance of the consultant's services consistent with the requirements of the prime agreement, which may be adjusted as the project proceeds. The consultant's schedule shall allow reasonable time for the architect and other consultants to review the consultant's submittals. Once approved by the architect, the time limits established by the schedule shall not, except for reasonable cause, be exceeded by the consultant or architect. So what he's really saying here is, again, the consultant's got to provide us a schedule. And when you read the A201, you're going to see that the contractor is supposed to provide us a schedule, a submitted schedule, and a schedule in general for the construction, which shall comply with the goals that the owner has established for the project regarding initial and final completion. And it should not just be messed with. It should be, if it grows or shrinks, it's got to be done by change order and approved by people with the authority to do that. So now there is this thing called force majeure or an act of God. A tornado happened, COVID-19 happened, right? A freezing warning like now, and these days is being temperatures, freezing temperatures all throughout the country almost. And that's an act that doesn't happen all the time that may trigger an extension in the schedule. You can request an extension in the schedule, but you got to really express the cause and you got to let the architect know about it if you're the consultant. And now I always want you guys to think about the hat that you're wearing within these agreements. Your hat is always and should always be the hat of the architect. That's what you're doing here. You're trying to become an architect. I don't want you to get like all caught up into whether it's fair or not fair to the consultant, whether it's right or not. We're following these contracts. These contracts were written by the AIA. We don't necessarily have to like it. We don't necessarily have to love it. Those are the contracts that we use for the AREs, and we just gotta abide by them, understand them, respect them, and know how to use them so that you can apply them. Section 2.8, the consultant shall maintain the following insurance. Again, they actually require you to have insurance as this agreement. And it's again because they're professionals. They're entities. They have to be liable if something goes wrong for their errors and omissions. And here are the amounts. So in this section 2.8.1, commercial general liability with policy limits of no less than such and such. A aggregate for bodily injury and property damage. We've already spoken about this in our B101, so I'm not going to get into details. Section 2.8.2 says automobile liability covering vehicles owned and unowned vehicles used by the consultant with policies limits no less than such and such. I'm not going to go through it. It's pretty much the same thing as the B101. The consultant may achieve the required limits and coverage for comprehensive general liability and automobile liability through a combination of primary and excess or umbrella liability insurance. There are multiple insurances, basically, a package of insurances to be able to add up to that amount. But again, provided such primary and excess or umbrella liability insurance policies result in the same or greater coverages as the coverages required under section 2.8.1, 2.8.2, and in not event shall any excess or umbrella liability insurance provide narrower coverage than the primary policy. The excess policy shall not require the exhaustion of the underlying limits only through the actual payment of the by the underlying insurers. Whole mouthful. I'm not sure how you would really apply a lot of it. Not that you really need a whole lot of it. Um, if you want to know more about insurances, call an insurance broker. They will, and I have one that I know. He doesn't pay me to give him advertisement. His name is Mike Jones out of Beverly, Mass. He's very nice, answers every emails, every questions. He's just really like, I mean, how much could you love an insurance broker? I like the guy very much. So section 2.8.4, workers compensation and statutory limits. That's just the limits that the state tells you got to provide. That's what you got to provide. 2.8.5, employer's liability with policy limits no less than an amount here. And then again, those amounts, uh, they put them in there. You fill them in. There may be a requirement by the owner of the project to an amount on these limits, and they got to do it. And we will know more about it. We read it on the B101, and we're gonna continue knowing more about it here. So section 2.8.6 says professional liability covering negligent acts, errors, and omissions in the performance of professional services with policy limits no less than. Right. So you guys are seeing we got car insurance, workers' compensation insurance, we got professional liability insurance, we got commercial general liability insurance, we got ooh, a whole lot, automobile insurance, right? Um, it's a bunch of different ones, and they're for different reasons. Section 2.8.7, again, this is a good section. It says additional insured obligation. You're gonna need to become familiar with this test. To the fullest extent permitted by law, the consultant shall cause the primary and excess or umbrella policies for commercial general liability and automobile liability to include the owner and architect as additional insureds for claims caused in whole or in part by the consultant's negligent acts or omissions. The additional insured coverage shall be primary and non-contributory to any of the architect's and owner's insurance policies and shall apply to both ongoing and completed operations. Mouthful. But it's really adding the architect and the owner in here for something that happens. If it happens and the cause is even a little bit the cost of the consultant. The architect's insurance will cover him for his own errors and omissions. The owner's insurance will cover him for his own situations, right? But this one is covering people for the things that they didn't cause, that was caused by this consultant. And by the way, the AIA, the Handbook of Professional Practice student version, have a lot of good text on sort of articles and when they need to be modified, and if they're being modified, what things do you agree to and what things you don't agree to when they're modifying an agreement. Trust me, you want to read that. They may have it at the Boston Architectural College. You can borrow it, or you can just buy it. The student version I like better for the Aries than what I like the the big professional version. I just that's the one I used and that's how I passed. So again, the consultant shall provide to the architect certificates of insurance evidencing compliance with the requirements in this section 2.8. Article 3, scope of consultant services. So the consultant shall provide the architect with the same professional services for this portion of the project as the architect is required to provide to the owner under the prime agreement. Interesting. It's just saying, listen, the architect is saying that you're doing plumbing. You are doing plumbing. The architect is saying you're doing plumbing for, let's say, the new bathrooms. You're doing all the plumbing engineering for those new bathrooms. You can't be saying that you're doing only the plumbing for a kitchen or you're doing the plumbing for. It's got to coordinate with what the architect's saying on the prime agreement. And remember, the prime agreement is the B101. By the way, Alan, I didn't. You joined a little after we're late. I didn't do the A201. I'm doing the C401 because it's so much closer to the B101 and it's so much related to what you guys are going through when it comes to the practice management exam. The A201 is much more aimed towards project management and construction evaluation. So I wanted to kind of keep these two together, B101 and C401. This is the consultant's agreement. And this is actually being recorded for your convenience. Thank you. The consultant shall provide its services in the phases and sequences directed by the architect and subject to the same standards and provisions that the architect is required to meet under the prime agreement unless otherwise described below. Self-explanatory. The consultant shall provide an amount of site visits during construction of the project. If the architect authorizes the consultant to perform additional site visits, the consultant shall be compensated for the additional site visits as an additional service. Okay. And then we have section 3.1.2. Set forth below any variations to or limitations on the professional services described in the prime agreement affecting the consultant services under this agreement. So here you're just gonna write like, well, you know what? I'm only gonna do, let's say it's a mechanical engineer. I'm only gonna be doing, you know, the heating design, supplies, and I'm not doing the returns or whatever it may be. They need to say it in here. What it really is saying also is, yeah, I'm agreeing to doing something on the project as per the prime agreement, but there's something that I may not be doing, or I may just do X amount to this extent, not beyond that. All right. They put it in there. So section 3.2, the consultant shall ascertain the requirements for this portion of the project and shall confirm such requirements to the architect. Very straightforward. Section 3.3. If required in the jurisdiction where the project is located, the consultant shall be licensed to perform the services described in this agreement and shall cause such services to be performed by appropriate licensed professional. Very straightforward. You got to be licensed to do that on that particular jurisdiction if it's required on that jurisdiction. If it's not, then it doesn't matter. So section 3.4, upon request of the architect, the consultant shall furnish to the architect with reasonable promptness interpretations of the contract documents prepared by the consultant. Okay. Section 3.5, the consultant shall, within time limits agreed upon or otherwise with reasonable promptness, render written recommendations on claims, disputes, and other matters and questions between the owner and the contractor relating to the execution or progress of this portion of the project as provided in the contract document by the contract. If there's any claims or issues with, that they're going through disputes and they actually have to do with this consultant may, well, shall actually answer to them. Then section 3.6, the consultant shall assist the architect in determining whether the architect shall reject work for this portion of the project that does not conform to the contract documents or whether whether additional inspection or testing is required. They may reject their work, just like we architects reject some portions of the work that are not in conformance with the contract documents. And by the way, that the owner could actually accept that non-conforming work, right? They can say, yeah, I will keep it. Does not mean that the building inspector will let in, but that can happen, all right? So Article 4, additional services. Additional services may be provided after execution of this agreement without invalidating the agreement. Upon recognizing the need to perform additional services that may arise as the project proceeds, as described in the prime agreement, the consultant shall notify the architect. The consultant, however, shall not proceed to provide such services until the consultant receives the architect's written authorization. The architect has no obligation to compensate the consultant for any additional services performed without such a written authorization, except for services due to the fault of the consultant. Any additional services provided in accordance with this section 4.1 shall be entitled to the consultant, to entitle the consultant compensation pursuant to section 11.2. It's a mouthful, guys, but just like we have additional services in our B101, they do, but they gotta let us know that they need to do those additional services. They need to render those services and why. And if we don't approve them to do them, they shouldn't proceed with it. Now, if they get our approval, they proceed, they get paid additionally for them. There's other reasons though. Like if there is, and again, there are all the reasons, and I don't know if they're saying any here, so I'm gonna read it again, because if there is a need by, let's say, a change in the codes, right? It's a change in the codes. They got to do it, But to that extent, I guess the good thing is always notify the architect, and we notify the owner. I'm going to read this again. Additional services may be provided after execution of this agreement without invalidating the agreement. Upon recognizing the need to perform additional services that may arise as the project proceeds, as described in the prime agreement, the consultant shall notify the architect. All right. So the consultant needs to do additional services. He's got to notify the architect, and he shall not proceed without approval. Okay. Then we go to Article 5, Architect's Responsibilities. I want you to pay attention to this here because just like we have responsibilities towards the owner, now we have responsibilities towards the consultant. And this is the same language for all consultants, okay? So long as you're using the C401. I'm going to try to make this a little bit bigger if possible. Wow, it's just never big enough. Let me see if I can do. Okay, that's perfect. Um, the architect shall provide available information in a timely manner regarding requirements for and limitations on this portion of the project, including a copy of the owner's program for the project. I, yes, ideally everything that you have that the owner gave you that relates to this, you got to give to them too, including the program. Um, 5.2, the architect shall indemnify. Sorry, that's a bad word. That's not the word I want here. The architect shall identify a representative authorized to act on the architect's behalf with respect to this portion of the project. By the way, you know how we have a representative in our on a B101? One is the architect and then somebody else also as a representative to the architect. Here we may have one, and it may not be the same person. It may be somebody that knows how to deal with a structural more within the office, or somebody that has a certain level of expertise or knowledge within the discipline that this consultant is working on, who may be able to, relay information and answer questions in a timely fashion and help expedite the process and smooth the process of the project, of the design of the project. So we identify that person here. The architect shall, the architect or such identified representative shall render decisions in a timely manner pertaining to documents submitted to the consultants in order to avoid unreasonable delay in the orderly and sequential progress of the consultant's services. The architect shall not replace its identified representative without the approval of the consultant, which shall not unreasonably be withheld. All right, so that's that. Section 5.3, on the consultant's request for design and coordination of this project, of this portion of the project, the architect shall furnish to the consultant in a timely manner, one, detailed layouts showing the locations of connections and tabulations giving sizes, loads, and other information on equipment design specified or furnished by others. Certain specialty elements that really relate to what this consultant is doing, they got to be put in here. And if it is an electrical engineer, it may be the fact that, hey, we're going to have an elevator in this building. We're going to have, an entire laundry room with a bunch of laundry machines and dryers. We're going to be having, so they got to give this information to them. Like, I remember working on this project that was 270 units in Salisbury. And we were anticipating like how many fridges there were going to be, how many units, how many fridges, how many like dishwashers, how many like all the stuff, like where the cooking tubs were gonna be electrical or gas, or all of that stuff, so that the electrical engineer could actually size his loads so that he can put the right, or request the right transformers and services and do a phase 1 or phase 2 transformer, and things like that. So that stuff. The equivalent to these on plumbing will be the same. Toilets, how many toilets and things like that, right? Like any specific things that we got to deal with. So we got to provide it. And then section 5.4, the architect shall confer with the consultant before issuing interpretations or clarifications of documents prepared by the consultant and shall request the recommendation of the consultant before providing interpretations or clarifications of shop drawings, product data, samples, or other submissions of of the of the contractor or upon change orders and construction change directives affecting this portion of the project. Anything really the architect gotta go back to the to this consultant on anything that has been changed within his scope of services, and they need recommendations. And honestly, the recommendation shouldn't be coming just from the architect; it should be coming holistically from whoever the consultant is that is involved in that change. Me personally, the way I would do it is, and these changes we're talking about changes during construction, not so much prior to. But during construction, you know, a plumbing fixture is being changed, a toilet is being changed, whatever, right? There's gonna be a change order on that. They're gonna put a new toilet. You know, what if the housing, what if the pipe that was supposed to be with that toilet that was sized by the plumbing engineer isn't the one that will be compatible with the new toilet? You gotta coordinate that stuff. You can't just approve change orders and change construction change directives without involving everybody in it, right? And it gets very, 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 very crazy. I mean, it really does. It really gets very intricate because changes may be triggering, like things are getting so sophisticated where a vanity that changes, right? Like a bathroom vanity that changes triggers a change in whether the faucets are three hole or single hole, which is something I'm dealing with right now, you know, or like this widespread or single, or some of those vanities have requirements for lighting. Some of them come with lighting in them too, and you're replacing all that stuff, and it's gonna trigger a change with the plumbing engineer. It's gonna trigger a change with the electrical engineer. It's gonna trigger a change maybe in the on the ceiling if the height of the vanity changes or something on the space. It's really not like, you know, your average Joe's. Everything's got to be thoroughly coordinated. So that's that. And you got to involve those parties prior to you like issuing, you know, because if the change order gets priced by the contractor, you can see it and see like, oh no, wait a minute, there's more things that need to change. You're only changing the vanity, but you also need to change the pipe. The plumbing engineer just informed us that the pipe has got to change and it's going to be costing more. So all of that stuff's got to be said in there. How do you know about the pipe? Because you've already told the plumbing engineer about it, and they will tell you about it so that you can confer the information to the contractor. Does it make sense? Very good. Good. All right. I hope it does. So then we go to section 5.5. The architect shall furnish to the consultant a copy of the preliminary estimate or updated estimates of the cost of the work as submitted to or received from the owner, bidding documents, bid tabulations, negotiated proposals, and contract documents, including to the extent they pertain to this portion of the project, change orders and construction change directives for the consultant's use in the design and coordination of this portion of the project. Exactly what it says, guys. So section 5.6, the actor shall advise the consultant of the identity of other consultants participating in the project and the scope of their services. You gotta let them know, like, hey, listen, you know, there is such and such a specialty consultant that will be dealing with such and such, and it's kind of close to your project. I want you to know about them. Just like we stated at the top, what the other consultants are and any sub consultants that the consultant may have, we also advise them of anything that they should be aware of. And sometimes it's things like, well, the owner has hired a separate consultant for all of the swimming pool plumbing. You are the plumbing engineer for the whole house. You're gonna get water into the building, into the property, into everything. You're gonna, you know, the civil engineers involved, right? I'm already mentioning two consultants. One is the swimming pool consultant, plumbing consultant. One is the plumbing engineer that will be doing the plumbing for the whole house, and one is the civil engineer that will be sizing the pipe that will go into the house, into the building. So all of those guys gotta kind of be on the loop, because if there is a special requirement by that other swimming pool engineer or consultant, they gotta know, because otherwise they'll be sizing the wrong pipe. I mean, it's just really critical that, you know, the pipes and things, everything's got to be thoroughly coordinated. So you state here anything special that's happening in here. So section 5.7, if the consultant reasonably requests information from investigation, service, test, analysis, and reports of the services of the other consultant not within the scope of the consultant services, the architect shall request that the owner furnish information of service or service. Something that's beyond that, you don't know why they need it, but they actually need it. Like, you don't have to necessarily understand that the consultant needs something. If it's a reasonable request, they need it for a reason. That's it. You just gotta get it, and you may not have it, so the owner has it. So you're gonna get that from the owner and get it to the consultant. Then we go to section 5.8. The architect shall be entitled to rely on the accuracy and completeness of services and information furnished by the consultant. We relied on their work. The architect shall provide prompt written notice to the consultant if the architect becomes aware of any errors, omissions, or inconsistencies in services or information. Just like the consultant is supposed to report that there may be some inconsistencies or errors or omissions by some other consultant, we are to do that to them. Those are our responsibilities towards them. You know, it's a little bit of do to others as you want to be done by, right? So section 5.9. Within 7 days after receipt of a written request, the architect shall request information from the owner as necessary and relevant for the consultant to evaluate, give notice of, or enforce lien rights. Within 7 days of receipt of such information from the owner, the architect shall furnish information to the consultant. Yep, the consultant could file a lien on a property, and anything that they need to be able to protect themselves with that lien, it's got to be requested to the owner. But they can't request it directly. They got to request it through the architect. And within 7 days, the architect requests it. And as soon as they get it, within those 7 days of they getting it, they got to reply it back. All right. Then we go to cost of the work. For purposes of this agreement, cost of the work is defined as set forth in the prime agreement. You guys have already read the B101, so you know what that is. Ideally, you guys have already read and listened to all of my B101 videos, which are many of them. So that's what the cost of the work refers to. The consultant shall review or prepare estimates of the cost of the work for this portion of the project to the extent such services are required for the architect in the prime agreement. We do cost estimates at each, we do it with the started at schematic design, and then we update it at the end, and then we update it at the beginning of design development, and then we change it at the end of design development, and then we update it at the beginning. There is this updates, and I want you to look into them in the handbook of professional practice. But where do we get the numbers for all of these other things? We can't possibly know all the numbers for like all the plumbing engineering and all the mechanical engineering. We will get them from them. They are the source. So they will give that to us too. And then 6.3, if at any time the estimate for the cost of the work exceeds the owner's budget for the cost of the work, the consultant shall make appropriate recommendations to the architect to adjust the project size, quality, or budget related to this portion of the project. Additionally, the consultant shall cooperate with the architect and the architect's other consultants in redesigning the work for this portion of the project to comply with the budget for the cost of the work. We have something like that, and on the B101, same thing applies to the consultant, okay? Then Article 7, copyrights and licenses. Upon execution of this agreement, the consultant grants to the architect a license to use the consultant's instruments of service in the same manner and to the same extent as the architect has granted a license to the owner in the prime agreement. It's just saying you can't give to the owner what you don't have. So let me give you a license that you can then give to the owner, as stated in the prime agreement. Because the prime agreement says that we give a limited license for this particular project to all of our instruments of service. And then there's actually a fee, as you remember on our last session, for the licenses, whether they continue with us or not. Like if they don't continue with us and they continue using our instruments of service, they got to pay a licensing fee on top of the termination fee, of course. So the architect and the consultant shall not make changes in each other's instruments of service without written permission of the other party. Never, 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 please, I'm going to say it again, never grab a drawing or a model that a consultant gave you and start messing with it and link it to your model and start issuing drawings. Because at the minute you did that, you just stepped into another profession. You just stepped and increased your liability. And you just really got in trouble. Why? Because you're not a mechanical engineer, you're not an electrical engineer, you're not a plumbing engineer, you're not a structural engineer. Okay? They are doing their stuff. You can mark it out by hand and say, hey, listen, there's an issue with coordination. And really, 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 you should be looking at coordination. Our world is about coordination as it relates to the consultants. We're not sizing them. We're not telling them, like, hey, put a HVAC unit here, put a, we can, we're not telling them the systems exactly how they should work and how they should do, because they're experts on that subject matter. All right. So do not mess with those things, right? Like typically we get surveys, we get the CAD files, and we put them in our file and we just reference them. We don't change them, we don't change the information, we don't change the dimension, we don't change anything. We're not supposed to. We're not supposed to, because we're not surveyors, professional land surveyors. We're not mechanical engineers if we were using a mechanical engineer, you know. So we're not supposed to do one another. Now, again, I'm saying no, just don't do it. Here it says if just don't do it if you don't have written permission. I wouldn't do it. I wouldn't do it even if I have written permission. I would let them do it. Why? Because that's their responsibility. I'm not gonna get into somebody else's scope of work. We're architects. We're not anything else. Remember the standard of care. Standard of care says that we got to do what architects do within our region and reasonably and such, right? So don't do anything that you're not supposed to be doing. So section 7.3, the consultant shall maintain on file and make available to the architect design calculations for this portion of the project and shall furnish copies thereof to the architects on request. Sure. Then claims and disputes. By the way, all of these is the same thing basically as what we've already seen on the B101. So I almost feel like compelled to skip it. All right. But I'm gonna read it because it's not so long. And we're on page 6. We may need another session to finish all of it. But I'm gonna read it. So, and I wanted to compare it. Go ahead, read the B101 and look at the C41 and say, well, what changes? Sometimes the only thing that changes is the word architect and it's changed by consultant. Consultant, architect. That's it. And then owner, architect, owner, consultant, architect. Really, it's really that simple. So any claim, and correct me if I'm wrong, any claim, dispute, or other matter in question arising out of or related to this agreement shall be subject to the same dispute resolution provisions as set forth in the prime agreement. Remember those? Yep. Mediation, arbitration, litigation, such and such, the same thing. And those are already determined there, so we don't even have to determine them here. Except that if the claim, dispute, or other matter in question is unrelated to a dispute resolution between the architect and the owner, or if the consultant is legally precluded from being a party to the dispute resolution procedures that are set forth in the prime agreement, the claims, disputes, or other matters in question shall be resolved in accordance with the procedures set forth in section 8.2. They have their own section. And if applicable, section 8.3. If such matter relates to or is the subject of a lien arising out of the consultant services, the consultant may proceed in accordance with applicable law to comply with the lien notice or filing deadlines prior to resolution of the matter under the dispute resolution provisions set forth in the prime agreement. Mouthful, guys, but just read it carefully. It will make sense. Then 8.1.2, the consultant shall indemnify. This is a good one. I want you to remember this one. This is a good one. The consultant shall indemnify and hold the architect and the architect's officers and employees harmless from and against damages, losses, and judgments arising from claims by third parties, including reasonable attorney's fees and expenses recoverable under applicable law, but only to the extent they are caused by the negligent acts or omissions of the consultant, its employees, and its consultants in the performance of professional services under this agreement. The consultant's obligations to indemnify and hold harmless the architect and its officers and employees does not include a duty to defend. Okay? They identify and hold harmless, but they don't necessarily defend them. It really means they're not representing them, they're not paying for their attorney's fees, basically, but they don't say attorney's fees. So the word defend, it means legal defense, like attorneys. All right. So they're not providing an attorney for the architect. That's what he's saying. So 8.1.3, the architect shall identify and hold harmless the consultants and the consultants' officers and employees from and against damages, losses, and judgments arising from claims by third parties, including reasonable attorney fees and expenses. This is the mutual waiver, right? You see it? What the architect's been, the way that the architect's been identified is the same way that the architect is being identified. So again, both of them is the same thing. Okay. Section 8.1.4, disputes between the architect and consultant arising out of the owner's acts, omissions, or responsibilities under the prime agreement shall be resolved in accordance with the binding dispute resolution method in the prime agreement. In the event such a dispute, the consultant shall be entitled to relief only to the extent that, according to the same provisions as the architect is entitled to recover from the owner after deduction from for the architect's costs incurred in presenting and litigating or arbitrating the claim, including legal fees, normal overhead costs, and apportionment to other affected consultants. I would say read these carefully again. And I do wanna get questions from you. Go to that Google channel, YouTube channel, and put questions in there. I want to see them. I haven't gotten any question, and it worries me because neither am I so great that nothing I say here is like so perfect that you don't need any questions, or like I don't think I'm so horrible that it's just not worth to even asking the question because you don't understand anything at all. So ask questions. Yeah, I think I'm in the middle. It's it's reasonable. And then we have section 8.2, mediation. I'm not gonna read it. Why? Because it is pretty much the same thing as what we did on the B101. Mediation still is mediation. And these are the different types of dispute resolution methods, just like in the B101. Arbitration, same thing. Consolidation and joinder, same thing. Termination and suspension, slightly different. So let's read that. Except as otherwise provided below, the architect may terminate its agreement or suspend the consultant's services pursuant to the same terms and conditions, I guess so, other than the amount of any termination fee or licensing fee set forth in the prime agreement. So he's saying the same thing that we're doing in the B101, we're doing here, but we're paying a different fee. Okay? Except as provided in section 9.1.2, in the event of termination of this agreement not due to the fault of the consultant, the architect shall pay the consultant a termination fee. There you go. And a licensing fee. Same thing. Notwithstanding section 9.1.1, in the event of termination of this agreement due to the owner's termination of the prime agreement, for the owner's convenience, same thing, but there's a fee here that the owner kind of pays to you and then you pay to the consultant. All right. It's pretty much all of these are the same. The miscellaneous provisions are pretty much also the same. It's talking about the reference of the A201. Talking about, I don't see anything in here that, same thing with the confidentiality. Compensation. Now, the amounts will be different, but it's the same idea. Additional services, same idea. Compensation when it's a percentage of the cost, same idea. The hourly billing rates, here it is. This is where they will put all their billing rates. Reimbursable expenses, pretty much the same idea as what we had. There was a list, and I don't have a list in here, but there you go. It's the same idea. Payment to the consultant, how the consultant gets paid. The consultant shall submit invoices for services and reimbursable expenses in accordance with the provisions of the prime agreement. So you see, whenever it says in accordance with the prime agreement, it's the same thing, all right? And then we go to special terms and conditions, if there's any. Then we go to our last section, which is the scope of the agreement. And again, it's saying, it has to be lawful, right? And it relates to the prime agreement again. And this agreement is comprised of what? So this agreement is the agreement itself and the prime agreement with any exhibits associated with it and any other exhibits associated with it. And who signs this? The architect and the consultant. So with that being said, guys, we just finished the C401. It shouldn't be that long for you to read it. So please go ahead, read it, comment on the YouTube channel, and enjoy the rest of your day.